Um, so I did receive both parties' filings. I reviewed those for last week. I reviewed them again for today. Any comments anybody would have?
Well, just for the defendants, my motion is pretty straightforward. The certificate on fees, I just wanted to emphasize this was three different defendants, and it was pretty lucky for everybody getting them all to waive conflicts and having the bond company and everybody let me represent as one unit because it saves significant resources as we proceeded through all of the process here. The court has found no factual basis for any of the claims against Wilson or Lexon, and just coming into a trial with no evidence and is particularly no expert witnesses to back up any positions they had with regarding to removing debris or cutting brush. The case is such that we presented money damages to Wilson that goes back to Dave's View. It's originally Dave's View's responsibility under the contract. So we're asking for the award of $10,000, which the evidence was $10,000 to $50,000. That hasn't been refuted anywhere. So we're just asking for the low end to stay reasonable. As the prevailing party, the defendants are entitled to attorney's fees under the bond statute, as well as making a claim for $10,000 or less. And as a matter of fact, I think the finding was pretty clear that this was a unsupported by law and fact action against all three defendants. It was frivolous, in other words, and we should be awarded attorney's fees on that basis. The attorney's fees itself are fairly limited because other than a couple depositions and then a hearing we had previously outside of court, there was not, it could have been much larger, in other words, with regards to discovery and that sort of thing. So we're asking the court to find the fees to be reasonable and award them to us, as well as follow the evidence at trial between $10,000 and $50,000 in damages that Dave's View has incurred as a result of this unlawful action and claim, and just complete intentional interference with the relationship of Dave's View and Wilson. And then, of course, the bond company is very significant here, and these parties may never fully recover what should have been a done deal when the real estate case closed and he took title in the land, but then wanted to fight. So the motion is straightforward. We're asking Your Honor to follow the evidence and enter the proposed judgment as we've provided. I think you have a clear copy with you.
I do. One, just a clarification question. As I understand, this is the total request for all three defendants. Is that my understanding?
Correct. It goes down to Dave's View because under their arrangement, Dave's View is ultimately responsible for hiring Wilson and then having C. Wilson
Okay.
and the bond be brought into this. So they're
That was what I understood it to be. I just wanted to clarify that. Ms. Long.
Yes, thank you, Your Honor. Couple of points I want to make. I'm sure you saw the declaration from my client essentially asking for the court's mercy on this. I'll reiterate my argument that I made at the close of trial, which is that there's no basis for awarding damages for essentially lost time as a result of engaging in litigation. In terms of the attorney's fees, I will point out that the complaint in this case was for between $11,000 and $25,000. So my client would argue that it's unreasonable for essentially the primary defendant in this case to spend over $30,000 on attorney's fees pursuing this case. In addition, we asked based on the submissions of counsel to the court, it's clear that this case did go to arbitration and there was a final decision that the plaintiffs decided to, that the defendants decided to de novo. So we had a final decision in this case much earlier. It was just not a decision that the defendants wanted to live with. So my client's position is that this case should have ended with arbitration. My client also, I believe that there is case law indicating that unless the answer or affirmative defenses specifically outline the basis for attorney's fees, that it may not be appropriate for this court to order attorney's fees. You have to give proper notice to the other party of the reason that you're seeking attorney's fees. And I believe when I reviewed the answer, it just said something generic like, we're seeking attorney's fees.
Mr. Pryor, any response to that?
If there was law like that, she would quote it and coming up with, there may be case law out there. Well, there may be case law out there. The legal basis for attorney's fees is well founded in law and fact here, and it's unavoidable. The facts are clear. You go after somebody's bond and you don't have any case against that bond, you're paying for the attorney's fees under the contractor statute. That's no secret to any practitioner or any contractor, including this plaintiff. This plaintiff doesn't know the difference between his own individual identity and his corporate or LLC status. And that just shows the further disregard for the law here and what we're up against. We would not be here. My clients would have made a ton of money had Petra just taken its land that it purchased and went about it and maybe did some maintenance before it resold it for a profit. But the fact is, they started this bogus lawsuit without facts or law supporting it and drug in not only Dave's View, who successfully sold the lot with no complaints other than the lawn or the grass or whatever we argued about, briars. And the bottom line is this plaintiff Petra caused unlimited damages to Wilson by making the claim to a big bond company that has to hire attorneys and has its own overhead that that C.E. Wilson's liable, and then Mr. Chad Wilson and his mother and other family members are liable, including Mr. Johnson, who testified. So there's a whole, you start a lawsuit against somebody, it's not just, Chad and his personality, it's against a whole group of people, bonds, you're taking people off of work, you're losing opportunities to create revenue. It's a total disruption. And the only conclusion we can lead here is it's entirely intentional by Eli Kimmel because his own personal disregard for corporate status, the LLC, the contractor's law, and for our entire legal system to present a case with no evidence. So in this case, if this case doesn't cry out for attorney's fees as well as damages when no expert or any witnesses or any evidence has been done to refute it, I don't know what does. So we're standing by our proposed judgment, Your Honor.
Thank you. So I'm not going to go back through my whole decision, but this is really a case where I think the lawsuit against the bond company and against Wilson was just unfounded. It's probably something that should have been dealt with by way of a summary judgment early on, but that didn't happen here. I don't know the results of the arbitration. I've not read that because it was sealed, and I don't read those when I'm doing a trial on a case that's been moved in because there's a reason for that. So not knowing where that came from in this matter, there's the cases against those two, I think I don't think I made a finding of frivolous, but they certainly could be. And I think under that alone, I think that is justification for attorney's fees, at least with regards to those two defendants. With regards to Dave's View, I don't think it was a frivolous lawsuit because obviously we went to trial and heard all the evidence. And once we heard all the evidence, I was able to discern where we were. And again, this was something I took under advisement. It wasn't the simplest case because bond law and contractor law and contract law is complex by its nature. So it seems to me that under the sales agreement, there's obviously statutory or contractual authority for attorney's fees for Dave's View. So I think all three have a legal basis for attorney's fees in this case. The damages were testified to. They weren't super specific, although they were uncontroverted at this juncture, and I don't know that I have a basis to. I think there's a sufficient basis, not necessarily just for attending the lawsuit, but was really more of a lost profits kind of thing for other things they could have been doing. And for the Wilson folks, I mean, they should have never been here. Bond company really doesn't have a whole lot of loss because they didn't lose anything because they didn't do anything until the trial, which was done through Mr. Fry. I did review through the attorney's fees declaration. I didn't see anything in there, and I didn't hear anything arguing that anything in there was inappropriate. It seems, given the nature of the case, and that we have essentially attorney's fees that would have been 3 attorneys, that doesn't seem unreasonable. I did review through the Petra Design declaration, and it's a very difficult situation he's gotten himself into, and I certainly can empathize with that. That is unfortunate, but it doesn't change the damages to the defendants. So given all of that, and I thought about this quite a bit because I thought about it before the last hearing and I thought about it since. I think this is a reasonable request for fees and damages. I think they were sufficiently proven at trial. So I will enter this judgment. It's a total of 10,000 plus attorney's fees of 30,835. I do have a cost of 1227.93, and I do have a judgment. Did you see a copy of that, Ms. Long?
I did see a copy, yes.
Any objections to the form of that order? Any objection to the form of the order?
I don't have it in front of me. The only question I have is about, is there interest?
There is statutory interest, like 12%.
It starts today. We weren't asking for prejudgment interest.
Okay.
And I can put that commencing today. So if I included it right after the last, essentially the judgment says it came before the court for trial, findings of fact were entered. It's now ordered and judgment decreed. The judgment is entered in favor of defendants against Petra Design. The principal amount of 10,000, attorney's fees of 30,835, cost of 1227.93 to bear interest rate of 12% per annum commencing 23 May 2025. That's what it says, and it's got a judgment summary at the top. So,
Okay.
All right, so I will enter that order, and I think that concludes this case for the time being.
I believe so. Thank you. Thank you, everybody.
Thank you.
That was
Apologize by last week. By the way, I'm now on Starlink out at my dad's house, and it's incredible product. I can't believe it. We were on some Hughes network before, and it dropped me a bunch of times. So I regret that. And I know Miss Long's had some drop calls too, probably. So anyway,
Right, life as in the internet has a way of getting back at us.
yeah.
All right, I've turned that over to
embarrassing.
go to the clerk right after we log off, and you all have a good weekend. Have a
Okay.
safe holiday.